So guys, in this lecture we will talk about the President of India. Okay, so we will talk about here the President of India. So Article 52 of the Constitution of India provided for the President of India post in the Constitution. Okay, so it said there shall be a President of India. Article 53, it said that executive power of the union is vested in the President of India. So under article 53 it is clearly mentioned that the executive power of the union is vested in the President of India. So let's talk about the President of India. What is the functions of the President of India? So function of the President of India are: one, it is the executive head of the union. So the head of the union, the executive head of the union is the president. Second, it is the highest constitutional functionaries. So president will act as the highest constitutional functionaries. It do the highest constitutional functionaries. Second, it is the first citizen of India and the supreme commander of armed force. So president of India is also the first citizen of India and he is the supreme commander of the armed force. Third, all the decisions of the union executives are taken in the name of President of India under the Article 53. So we have understood the function of President. One, all the decisions of the union executives are taken in the name of President. This is mentioned in the Article 53. Second, he is the first citizen of India and he acts as the supreme commander of the armed force. Third, he is the executive head of the union. Next, he is the highest constitutional functionaries in the India. So this is all about the president functions. Now let's talk about the what do you mean by the executive power. You know, in the article above, in the article 52, there is a President of India. Article 53 says their executive power of union is vested in the president. But what is this executive power? Who have defined this executive power? So this executive power definition is given here in the Ram Javaya versus State of Punjab. There was a case between the Ram Jaivaya and State of Punjab. It defined the executive power of the president. So what is the president executive power was defined in the Ram Jaivaya and State of Punjab case. It says, suppose there are different functions. So we have collected all the functions at one place, and when we remove the judiciary and legislative functions, then whatever the residual functions we are left with, it is known as the executive power. So we will define the residue of the functions that are left behind after taking away the legislative and judiciary functions. Means after we have taken away the judiciary and legislative functions, the residue of the functions will be known as the executive power, and this was defined in the Ram Javaya versus the State of Punjab case. Okay, so that's it. Now let's talk about some executive powers and functions of the presidents. We will look what are some example of the executive power and functions. So first is the administrative law. So he has to be the administration of the law, initiation of the law, and maintenance of the law. So three things regarding the law. These are here: administration of the law, initiation of the law, and maintenance of the law. Second, he also determines the government policy. Okay, government policy is determined by the president. This is the executive power. The next executive power is the promotion of social and economic affairs. So social affair, economic affairs promotion is the executive power. Okay, and then next is the direction to the foreign policy. Okay, so to give the direction to the foreign policy is also the executive powers or the functions. These all are the executive power and functions of the the president. Article 54 regarding the president, it tells about what? It tells about the electoral college. This means how the president election is being done is mentioned in the article 54. So it says that it is indirectly elected by the electoral college. But what is the electoral college? We will see here what is the electoral college. Electoral college means there will be some group of people. Some will be the MPs, elected MPs, and some will be the MLAs, and the means elected MLAs. Plus along with the elected MPs and elected MLA, there will be some member of the Delhi and Pondicherry MLAs will also be there in the electoral college. Why? Because two-thirds of majority and 50% ratification is needed for the amendment. Actually, amendment was done in the year 1992 by the 17th amendment, where by the two-third majority plus 50% rectification, which was needed there in the 1992. By this amendment, Delhi and Pondicherry elected MLAs were also, given the membership of the electoral college. So we will come here. So till date, so is now since Jammu Kashmir is also a UT, but till now it has not been added, because to add it we have to go for the constitutional amendment, because earlier we have done in the year 1972. So it may be required to in order to add the JNK. Okay, so from the prelims point of view, we have some table here, like the Raj Sabha is there, Lok Sabha is there, Legislative Assembly, and member Legislative Council. So if you talk about the Raj Sabha can never be suspended, Raj Sabha can never be dissolved, and the Raj Sabha can never be abolished, because two-thirds of the member of the Raj Sabha is always retiring, and again a new member is coming every 2 years. So it cannot be suspended, it cannot be dissolved, it cannot be abolished. Second is the Legislative Assembly. Lok Sabha member can also not be suspended, but they can be dissolved. Yes, they can be dissolved. They can be abolished. No, they cannot be abolished. Third is the Legislative Assembly. Legislative Assembly member can be suspended, they can be dissolved, but they cannot be abolished. Okay. What about the MLC? MLC can be suspended, they can be dissolved, but they cannot be abolished. Okay, they cannot be abolished. So what we can abolish? MLC can be suspended, they can be dissolved, but they can be abolished. Okay, I think I am said wrong here. So MLC suspend. MLC cannot be suspended, because two-thirds of the member is again coming, so we cannot suspend it. That's why cross put here. Dissolve, yes, we cannot dissolve. Abolish, yes, it can be abolished, because Article 169 provides for the creation of MLC, so it can be abolished. But if it is there, then it cannot be suspended, it cannot be dissolved. For the Raj Sabha, it even cannot be abolished, so it cannot be dissolved, it cannot be suspended. For the Lok Sabha, Lok Sabha, it cannot be suspended, it can only be dissolved after the 5 year or in between, but it cannot be abolished also. Legislative Assembly, yes, it can be suspended. Legislative Assembly, yes, it can be dissolved, suspended in the emergency, dissolved 5 year after or in between, and abolished, we cannot abolish it. Okay, so this is all about these things. So now let's talk about the election of president. So election of president, how president is being elected. So for the election of president, there is indirect election for the president of India. Electoral college consisting of member of both the house. Actually, it is the elected member. So in the electoral college will consist of the elected member of both the house plus elected member of MLAs. Okay, so this will be the composition of the electoral college. So Constitutional Amendment Act 1992, that is the 17th Constitutional Amendment Act, it provided Delhi and Pondicherry MLAs to be the member of the electoral college. Okay, electoral college is there for the indirect election of the presidents. So there are some elected member of the MPs and MLAs, but what is the value of the vote of MLA and MP? Is it different or same? How will you distinguish it? How will you know it? So basically, the giving the value to each vote, the concept is basically on the principle of equal representation of the state and equal representation of the parliament. The vote should value should be such that they are equally represented. Means state and parliament are equally represented in the electoral college. Basically, president represents the nation and the state both at the federal level. That is not the unitary bias. Means president is the representation of nation as well as the state. So it basically supports the federal structure. It not the unitary or it is not biased case. The fundamental concept is that some of the votes value of all the MLAs across the states in India, like there are different states in India, Bihar, UP, Jharkhand, etc. Some of the values of votes of all those MLAs across the Indian states, their values of the vote, some of the values of the votes of MLAs across all over India, their sum should be equal. Their sum should be equal to some of the vote value of all the MPs in the electoral college. Okay, so their both the vote value should be equal. Now, if you want to know what is the vote value, of an MLA. So basically, the vote value of MLA will be calculated by simple formula. We know we have to consider the 1971 census. For example, let's talk about what is the vote value of Bihar. So in Bihar, the state population of Bihar according to 1971, we have to put here, okay, and the total number of elected MLAs of that state. So total number of the elected MLAs of that state. So maybe some number is there. So we have to take the ratio of the state population according to the 1971 constitution and the total number of elected MLAs that is there in the legislative assembly in the state. So that ratio will give you the vote value of one MLA. Now we will be interested in knowing what is the vote value of MPs. So basically vote value of MP, if you are talking about the vote value of MP is given by the formula. We have to first of all find the what is the sum of the vote value of all MLA in the electoral college. So inside the electoral college there will be the elected MLAs from different states. If we sum the vote values of each MLA across all the states which is there in the electoral college and divide this by all the MPs in the electoral college, number of MPs in the electoral college, then the vote value of one MP is calculated. Okay. So now let's talk about the nature of election. So what is the nature of election for the president? So the president is elected by the system of proportional representative and through the single transferable vote system. So two things need to be taken care of. One is the system of proportional representation and second is the single transferable voting system. So what do you mean by the system of proportional representation and what do you mean by the single transferable voting system? We will take these points in the respective slides ahead. Okay, but keep in mind that election is always held through the secret ballot. So there will be a secret ballot through which the election will be held. So three things we have to keep in mind. One is the system of proportional representation, single transferable voting system, and through the secret ballot. So through the secret ballot. Okay. So one thing is more there. Whip is not issued by the party. So during the election of president, no party is going to issue the whip. Okay. This you need to take care of. Second is MLA will participate. Okay, so MLA will participate in the presidential election only. It is done only here only if the legislative assembly is not dissolved. Means suppose there is a legislative assembly of Bihar and it has been dissolved for some reason, and in between there is a electoral college formation for the president election. Then this elected member of the legislative assembly, which was supposed to be the member, will not be voting here, will not participate because legislative assembly need not to be dissolved here. Okay, and however it may be suspended during the presidential rule in that state. So but in case the legislative assembly is just suspended during the presidential rule, in that case will MLA participate in the presidential election? Yes, it will participate, but if it is dissolved then it will not participate. So this is a very simple understanding. Now let's move ahead and see our basic question: what is the proportional representation? What do we mean by the proportional representation? Okay, so proportional representation simply means states like Bihar, UP, etc., whatever the states. So states are represented in the electoral college in proportion to the population of the state. In what proportion? In proportion to the population. So population is very important thing you have to consider here. So this means the states are represented in the electoral college with respect to the proportion of the population of the state as per the year 1971 census. Okay, so this is the meaning of proportional representation. Now, if it is so, we can write vote value is directly proportional to the state population of the year 1971 census. So since we have seen it, now let's talk about the single transferable voting system. What do we mean by the single transferable voting system? Let's talk about. Okay, so suppose there is election of the president, and the candidate who wants to become a president is candidate A, candidate B, candidate C. Okay, so suppose a voting has been done, and who has voted, the member of the electoral college has voted. So for candidate A, the first preference vote is 40, second preference vote is 33, and the third preference vote is 45. In the similar way, for candidate B, there is some first preference voting, second preference, third preference. For the candidate C also, there is first preference, second preference, and third preference. So now we will see here how these things are, basically how the winner will come here. Okay, so the how winner will come here will be here. Okay, so let's say there are total 100 members. In the electoral college, which means 50% of 50% will be how much? It will be 50. Okay, so 50% will be 50. Now the condition is that if the first preferential vote is more than 50%, then candidate will win. So if any candidate is having first preference vote more than 50%, then they will win. So in our previous example, we have here the first preferential voting is 40, 41 and 19. This means no one is having more than 50 number of first preference vote, so no one will win. So what will happen? We will see the second point. So second point says, if no winner in the first preference, then eliminate the candidate with lesser number of first preferential vote. So if there is no clear winner, then in the second case we will go to the table and we will eliminate the candidate who is having very least number of the first preference vote. So the first preference vote is least in case of candidate C, so he will be eliminated. Now only A and B is remaining. Okay, so now let's see the third point. It says one who gets eliminated, his first preference maker's second choice will be transferred to the rest of candidate. Means what? Means this, that this candidate C was removed. Now the candidate C has got 19 number of first preference vote. Means 19 people elected this in the first preference. Now since this has been eliminated, these 19 people, suppose there are 19 different people, these are the 19 people, suppose. So these 19 people second preference will be transferred to the first preference of candidate A and candidate B now. Okay, so this is said in this point. So I will again read: one who gets eliminated, his first preference maker's second choice will be transferred to the rest of candidate. That is, in above example, 19 people or member gave the first choice to category C, but since C is eliminated, his second choice will be transferred as a first choice to the remaining candidate. Okay, now the voting, now we will again count the vote. If If any candidate get more than 50 percentage, then he will be winner, and if it is not, the process will continue. In this way single transferable voting system will work. We will note here that electors can indicate as many preference as there are the number of candidates in the contestant. So for the president election, if there are 5 candidates, then one can give each 5 preferences. But system of voting is also this system of voting is also known as the preferential voting system. So this system of voting is not only known as the single transferable voting system, but it is also known as the preferential voting system. Second is that the second preference, third preference, and so on. The second preference, third preference, and so on preferences. This choice is not mandatory to be given. So if one can give only first preference, no one will force him to give the second, third, and fourth preference. Okay. Now we will again revise that. In first round of counting, only the first preference vote are considered, and if any candidate gets 50 percentage first preference vote, then he will win. If not, then candidate with least number of first preference vote is eliminated, and the second preference of electors of eliminated candidate whose first choice had now been eliminated will now be transferred among the rest of candidates. Again 50% majority is seen, and if it is passed, then the candidate will win, otherwise the process will continue. In case of India, has there been any instance where the second round of voting was done? So in India, during the V.V. Giri presidential election in the year 1969-1974, second round of counting was done. So it was the year 1969. This is important only from the prelims point of view. Now let's talk about some of other aspects of the election. So what are some other aspects of election we will talk here? So now we will define the term what a returning officer. Okay. So one who collects the nomination paper and checks it and maintain it, it is known as the returning officer. Secretary General of Lok Sabha and Secretary General of the Rajya Sabha in turn by rotation will act as the returning officer of the presidential election. In case of this year, July 2022 presidential election, which was the 16th election to select the 15th president of India. So in the July 2022 president election, the returning officer means one who collect the nomination paper and maintain the nomination paper. So in this year, it was the turn of Secretary General Rajya Sabha. So again, in upcoming presidential election, it will be the Secretary General Lok Sabha who will act as the returning officer of the presidential election. Again, if you know, the presidential election and vice presidential election will go hand in hand. So this year, since Secretary General Rajya Sabha has acted as the RO of the presidential election, so Secretary General Lok Sabha will act as the vice president election returning officer this year. Okay. Now let's talk about something new. The nomination paper. Now we will talk about the nomination paper. The nomination paper of the candidate contesting in the election must get proposal from 50 electors. How many electors? 50 electors. So if a candidate A wants to stand as a candidate for the president, then his proposal should be from the 50 electors, and it will be seconded by another 50 electors. Means the nomination paper of candidate A contesting in the election must get proposal from the 50 electors. Electors means those who is the member of electoral college. Okay. and seconded by another 50 electors. Now, what happened when there is some dispute arising out of the presidential election? So, in case of the dispute which is there in the presidential election, that will be headed by the Supreme Court, and decision of Supreme Court in this regard will be final and the binding. Okay. So, who is saying this? So, this is being said by under Article 71. One thing you should remember: all the decisions which is taken by the president, okay, all the decisions taken by the president or the decision taken by his name, taken in his name, remain valid when the election of president is declared void on any ground, even if the election of president is declared void. Okay, so declaring the presidential election void will take some time. In between, president may have passed some bills and that have become act. So will that act prevail or they will be null and void? So it said that since the decisions were already taken, so this was taken, president is only the nominal head, so this was taken by the COM, so this will not, all the law will prevail even if the election of president is declared void. Now let's talk quickly about the presidential qualification. So what is the qualification of the president? So he should be the citizen of India, one thing. He should have completed the age of 35. How many age? 35 years of age. So, and he should not hold the office of profit. He should not also hold the office of profit, and he must be qualified to be elected as the member of legislative Lok Sabha. So three things is there. One is very simple, that is he should be Indian. Second, age of 35. Third, do not hold the office of profit. Fourth, should be eligible to be or qualified to be the member of Lok Sabha. So these are the things. So now we have mentioned the office of profit. So we will talk here about what is the office of profit in the case of president. So for the president, the office of governor, vice president, union minister, state ministers, they are not regarded as the office of profit. So this means if someone is governor, if someone is a vice president, if someone is a union minister, if someone is the state minister, they will not have to give the resignation, because by having, this means they are eligible. Okay, this means they are eligible. This means they are not holding the office of profit, and they are not regarded as the office of profit. Okay, so now let's say what will be the case in case of the member of parliament of Rajya Sabha, Lok Sabha. If MP of Lok Sabha or Rajya Sabha or MLA wins as a president, then he is deemed to have vacated his seat in the union or state legislature before entering in the office of president. So if a Lok Sabha member, Rajya Sabha member, MLAs of the state wins and become the president, then he is deemed to have vacated his seat in the union or state legislature before he enters in the office of president. So in simple language, we will say MP's MLA who was member of legislature ceases to remain member once he wins as the president and assumes the office of president. Therefore, president in no circumstance is a member of parliament, but he is the integral part of the parliament. Okay. Now we will take some questions here. That may be your doubt also. So the question is, what are the ground on which we challenge the election of president? So we can challenge the election of presidents as per the Article 71 only. Article 71 say that no election can be questioned on the ground of vacancy in the electoral college. This means there can be vacancy in the electoral college and still the presidential election can be held and valid. Okay, so no one can doubt over the vacancy. Second is, petition can be filed within the 30 days only, and that too by a candidate contested in the election or by a group of at least 20 electors. Elector means the electoral college member joined together. So it should be either the one who is contesting, they will file the petition within 30 days, or the group of 20 electors added together, they will file the nomination. This petition can be filed only on the two ground. What are those two ground? Those two ground are the nomination of the candidate if it is wrongly rejected, so you can file the petition. Second, elected candidate is wrongly accepted, so maybe some candidate nomination paper is uh, rejected, that rejection may be wrongly done, so you can, this is the one ground. Second, some other person nomination paper is accepted, but it may be it may be wrongly accepted, so you can challenge over this and file the petition. These are the two grounds. Now we will see the Article 60. What is Article 60? Article 60 talks about the oath of the presidents. Who administered the oath to the president? This CJI. CJI means, so we were talking about the Article 60. Article 60 talks about the oath of the president. The Chief Justice of India administered oath to the president, and under the Article 61, the impeachment of president is mentioned. Okay, impeachment of president is mentioned in the Article 61. Now let's quickly talk about the term of office of the presidents. So talk of term of office of the president. So one is the 5-year tenure. So it is for the 5 years. Second is the upper age of the president or the vice president is nowhere mentioned in the constitution. So what is the upper age? What is the upper age? Nowhere mentioned in the constitution. So he can be elected how many times? Any number of times. He can be elected any number of times or the n number of times. Third, there can be vacancy in the office. So there can be vacancy in the office of the presidents, and that vacancy may be on the basis of three ground. One, there is death. Second, there is resignation. Third is the impeachment. So there can be vacancy in the office of presidents due to the death of presidents, resignation of the presidents, and impeachment of the presidents. If vacancy is created in the office, then next election for presidents is to be held within the 6 month. How many month? The next election of the president need to be held within the 6 month from the vacancy. But till then, what will happen? So till then, the vice presidents will act as the presidents till the new president is elected. So vice presidents will act the presidents only after the oath has been administered upon him by the Chief Justice of India. Okay, so now let's talk about the impeachment of presidents. So we have already said that impeachment of president is provided under the Article 61. So under Article 61, the grounds of impeachment has been laid down. So we will see the what is the ground of impeachment here. So president can be impeached upon the ground of violation of constitution. But what action of president will amount to the violation of constitution is nowhere described anywhere. It is not described in the constitution. So therefore the ground of impeachment or the violation of constitution by the presidents is the political determination done by the parliament. So ground of violation of constitution is nowhere mentioned. It is merely the political determination of the parliament. So now we will here look upon what is the algorithm for impeachment of the president at a glance. So first of all constitutional violation of president should be there. Okay, so if someone feels there is a constitutional violation by the president, which is the political determination by the parliament, so basically a resolution seeking the impeachment should be moved in any of the house. So in which house? Any of the house. So that resolution must be supported by not less than how many member? The 1/4 member of that house in which resolution is being seeked. Suppose in the Lok Sabha resolution is being seeked, then 1/4 of the Lok Sabha members should come and support the resolution for impeaching the presidents. So this point we have discussed. Now resolution can be taken off in the house only after the expiry of the notice. So this means a notice must be served to the presidents that we are going to remove you. Resolution is there in the Lok Sabha or any state. So 14-day the notice should be given. So after the expiry of this notice only resolution can be taken off in the house and can be discussed. If the house passed it by not less than 2/3 of the majority, how much? Not less than the 2/3 of the majority, then the motion is transmitted to the other house. So in the house, this should be passed by 2/3, not less than 2/3 majority, then it goes to the other house. Suppose the other house will, the other house will act as the investigating house. It will investigate or cause to investigate all the charges that is there on the president. So, president can defend his right by hiring a law of his choice in the second house only. Therefore, second house functions as the quasi-judicial in nature because president can defend here by hiring the lawyer of his choice. Okay, so second house will act as a judicial, quasi-judicial nature. But keep in mind, the impeachment of president is not judicial action. We will elaborate this point in upcoming slides. So after the investigation, if motion is passed in second house also by not less than two-thirds of the member of the second house, then the president is impeached. Okay, so this is all about the impeachment of the president. Now let's talk about some noting point is there that all the decisions taken in the name of presidents by the presidents remain valid even after the president is impeached. Okay, second, there can be the judicial review of the president's impeachment to check or to check the misuse or to check the political interest of the party or any council of ministers or any parliament. There can be judicial review. Okay, this is very good point. Next is that impeachment of president is legislative action, but the removal of governor, Supreme Court, High Court judge, Chief Justice of India, even the CAG, they are both executive plus legislature, but president case it is only the legislative action. Next is that nominated member of the parliament although are not the member of electoral college. This means we have already said that in the electoral college there will be the nominated member from the Lok Sabha, Raj Sabha and nominated member from the MLAs. Okay, so one statement is there. The nominated member were earlier not the member of the electoral college, but yet they will participate. But they will participate in the president impeachment cases. Okay, why they will participate? Because it is the parliament who is responsible for the impeachment of the presidents. So whole parliament will participate. This means both nominated as well as elected. Since it is the action of the parliament, even the elected member of the legislative assembly who are there in the electoral college to elect the president, since the impeachment is not the action of the state, therefore even the elected member of the legislative assembly or MLA of Delhi and Pondicherry, though participates in the presidential election, they will not participate in the impeachment. So we will make one conclusion here that only the parliament members, that is MPs, whether elected or nominated, they participate in the impeachment. That is, no state legislature participate in the presidential election. Now let's talk about the veto power of the presidents. So what are the veto power of the presidents? So first we will before discussing the veto power, we will define this. We will discuss this in terms of the types of bill. So there are different types of bill. So we will take one by one. One is the constitutional amendment bill as per the Article 368. Second is the money bill. Third is the financial bill. Fourth is the ordinary bill. Okay, so there are different bill. One is the constitutional amendment bill, which is under the Article 368. Second is the money bill. Third is the financial bill, and next is the ordinary bill. So assent of president is required in all these bills, and the assent of president in these bills are described as below. One is the Constitutional Amendment Bill 368. So, after the 24th Constitutional Amendment Act 1971, if such bill is passed by both the houses and it is passed to the president, then for such bill, president has no choice other than give his assent. So we are talking about the constitutional amendment bill. After the 24th constitutional amendment bill 1971, if this kind of bill is passed by both the houses and it is passed to the president, then such bill the president has no choice other than giving his assent. Okay, so this is about the constitutional amendment bill. Now we will talk about what will happen in case of the money bill to the president. When the money bill is money bill after passed by the parliament is sent to the president, then under the convention president shall give his assent to the money bill. But on an advice of the cabinet minister, president can even exercise his absolute veto power to withhold such a bill. This means in case of the money bill, under the convention, the president should give his assent once it is passed by both the houses. But as per the advice of the COM, president can use his which power, the absolute veto power. Means the COM recommendation is necessary to use the absolute veto power. For money bill, he can use it absolute veto power to withhold such bill. Okay. Now let's talk about the financial or ordinary bill. So financial bill or the other ordinary bill, we will take all this bill here only. So for the case of financial or ordinary bill, president has the four options. How many options? Four options. One, he will give the assent to the bill and the bill is deemed to be passed. Bill becomes the act. Second, he uses the absolute veto to withhold the bill on an advice of the COM, because using absolute veto by president is not his discretionary power. So this means that in one case it will pass the bill and the bill become the act. Second, he will use the veto, absolute veto power. Absolute veto power, we have seen in the above slide that it was used in the money bill. So here also the president can use absolute veto power even in the financial or ordinary bill, but this will be only on the advice of the COM, because using the absolute veto by the president is not his discretionary power. Next is the suspensive veto of the president. So it may be the case that a president may send back bill to the parliament with some or without any suggestion. In such case, if bill is again passed with or without considering any presidential suggestions, then president is bound to give his assent. This means president will one time send for consideration, will give his suggestion. Maybe the parliament will agree with suggestion or will not agree, and again pass to the president. Then president has no option than to give his assent. So in this case, we will say that suspensive veto has been used by the president. So now let's say about the fourth point. The fourth point is that he can use his pocket veto. Which veto? Pocket veto. What is pocket veto? Pocket veto means he may allow the bill to lie on his table for infinite period without giving assent to it. So he may not be giving the assent and bill may be lying on his table. In that case, we will say the veto power has been used by the president. So this using of the pocket veto is his discretionary power. Okay. Now let's say, is president bound by the advice under the Article 74? Is President of India bounded by the advice of Article 74? Means we will first see what is Article 74 here. Okay. In original form under the Article 74, it is said that the COM headed by the Prime Minister will aid and advise the President of India. But Constitution did not explicitly explain whether such an advice was binding or not. Under the convention as followed in England, he would go according to the advice of COM in those days. So basically under the Article 74, COM, who is headed by the Prime Minister, will provide aid and advice to the President. But is this aid and advice binding? Constitution did not explicitly mention whether this is binding to President or not. But as per the conventions which is there even in England, so President is actually basically binded by this COM advice. However, there was one amendment done in the 1976, that was 42nd Amendment Act. In the 42nd Amendment Act 1976, what happened? Article 74 was amended, and President was said that he is bound by the advice of COM. So President was made bound by the advice of COM. After the 44th Constitutional Amendment Act in the year 1978, there was 44th Constitutional Amendment Act just 2 years after it. In this is also the latest version of the Article 74. So now it has the provision that President may ask the COM, means Council of Minister, he will ask once to reconsider the advices. So he will just ask, please reconsider the advices just for once. However, he shall then act according to the advice given by COM after such a consideration. So after after the president ask the COM to please reconsider the advices, however, he shall act according to the advice given by COM after such a reconsideration. Now we will talk about the ordinance power of the president. So what is the ordinance power of the president? So ordinance power of the president is given in Article 123. It is the legislative power of the president which helps enables the smooth functioning of government in rapidly changing environments. In example, means in a rapidly changing environment like Russia-Ukraine war going on, in this kind of rapidly changing environment, in order to have the smooth functioning of the government, the legislative power of president is required. So ordinance provide this sorts of legislative power which helps, which enables the smooth functioning of the government in the rapidly changing environment. So this is one point. Second, it is the legislative power of the president which is co-extensive and co-terminus with the legislative power of parliament. So there is the parliament. So legislative power of president is co-extensive and co-terminus to the legislative power of parliament, and it has, this means it has the same effect as the parliament. Okay, this act is similar to the act of the parliament. So basically, if we have seen the ordinance, what is ordinance, how we will issue the ordinance, how the president issue the ordinance. Ordinance is issued by the president on an advice of the COM. So he will not issue the ordinance by his own, but he will issue the ordinance by the advice of the Council of Minister. When there is one or both the house of the parliament not in the session, the condition required is there is a red line, that is one house or both the house of the parliament is not in the session, then as per the advice of the COM, president can use the ordinance to make the law. So but the issue of ordinance in the hand requires the immediate legislation after the session resumes. This means ordinance need to be re-approved by the parliament or approved by the parliament within the 6 weeks of re-assembly of the house. Because ordinance was made when both the house was not in the session or one house was not in the session, ordinance was made as per the advice of COM. Now if the house has reassumed, then within the 6 weeks from the date of reassembly of the house, ordinance need to be approved by the parliament. But what we can do from the ordinance? What are the things that we can do from the ordinance? One, it can be used to issue the new legislation. So if we want to make new legislation, then we can issue the ordinance. However, it cannot amend the constitution. We cannot amend our constitution by using the ordinance. Third, it can be used to make the new law or repeal or amend the already issued laws or ordinance. Means it can be used to repeal. We can repeal or amend the existing or already issued laws or ordinance. Now, how you will check the misuse of ordinance? So there are many safeguards in place to check and weed out the misuse of ordinance. So ordinance misuse can be checked by different points. One, ordinance is subjected to the judicial review. One thing. Second is that once the session of the house starts, the ordinance need to be approved within the 6 weeks from the reassembly of the house of the parliament. This is again a two checkpoint given to prohibit the misuse of the ordinance by the president. So can president seek any advice from the Supreme Court? If yes, on what grounds? Basically, under the Article 143, Supreme Court has very special advisory jurisdiction which it offers only to the presidents. Okay, but when it is sought by the president, then only it offers on the ground of two categories. What are those two categories? on which it can offers its advisory jurisdiction to the presidents when presidents seek it. So the two conditions required is that there is some question regarding the law or the matter is of public importance. So it should be the question regarding the law or the matter of the public importance. Second, there is dispute arising out of any pre-constitutional treaty or agreement. So there may be pre-constitutional treaty or agreement in some kind of dispute is arising, then Supreme Court under Article 143 may provide the advisory jurisdiction to the presidents. Now we will talk about the power of the presidents. What are the different powers that is been given to the Indian presidents? One is the discretionary power of the presidents. So what is the discretionary power? And we will talk about this in the coming slides. Then we will first see what are different kind of power. First is the discretionary power. Second is the military power. Third is the legislative power. Fourth is the diplomatic power, and other is the administrative power. Some more power are there, like the financial power, like the power are also provided under the Article 72. So now we will go one by one. We will see first what is the discretionary power of the president. So discretionary power of the president, some articles are there, like Article 74, Article 78, Article 78C, and Article 85. We can infer discretionary power from these articles. So first of all, we will check what is the discretionary power. So Constitution of India has not explicitly listed out the discretionary power of president, but some may be inferred. But the same, the discretionary power may be inferred from the various provisions mentioned in the Constitution of India, and some of them are listed below. 1. Under the latest version of the Article 74, when the President sent back the COM advice for reconsideration, he does so by his own discretion. So this is the discretionary power of the President. Second, under the Article 78, it is mentioned that PM will inform the President about the affairs of administration or the affairs of Parliament, that is about what is ongoing and proposed legislation. So basically the President, Prime Ministers will inform this kind of things. But this means the President has the right to be informed by the Prime Minister on these issues. So President can call upon the Prime Minister to inform about such issues in his own discretion to seek the required information. Third is under the convention, which means not mentioned in the constitution, that president enjoy a right to warn. So he can warn, and also a right to encourage. He can encourage whom? That is the cabinet of ministers. Next is a president uses the suspensive and pocket veto. So one is the absolute veto. So absolute veto is used by the advice of COM, but the suspensive veto and the pocket veto is used by the president in his own discretion. Next is that under the Article 85, it is clearly mentioned that not more than 6 months should pass between the two sessions of Parliament House. Normally, President summons the sessions of Parliament in the form of 3 regular sessions on an advice of the COM. But if COM does not advise President properly, such that more than 6 months has been passed, such since last session of the House, in such condition, President in his own discretion will may summon the session of the Parliament. It means 6 months has been passed, but COAM is not advising President to summon the session. In that case, President will use his discretionary power and will summon the House. Next is when no party or coalition of the party enjoy the majority, that is there is the hung parliament, which means no parties or the coalition of the party enjoy the majority. It means there is no majority, there is a kind of hung parliament. Then the president in his discretion may call upon any leaders of the political party to please come and form the government. Okay, so similarly, the President dissolves the Lok Sabha on an advice of COM only if the COM enjoys the majority in the Lok Sabha. If COM does not have majority in the Lok Sabha, then President in his discretion may or may not dissolve the Lok Sabha. That is, if Lok Sabha is dissolved, then COM advice regarding the dissolution of a Lok Sabha is not required. Next is, in case of the caretaker government, only day-to-day administrative decisions are required to be made. It is the discretionary power of the president to decide upon which decision is the decision of necessity and to be made during the caretaker government. Now we will talk about what is the caretaker government. So when fresh elections are held and new PM is elected and old PM has resigned, then it will take time to fill the seat of new president. Not president is only done here, it is the PM. So till the new PM come, it will take time. So till then, sorry, yes, till then earlier COM continue as a caretaker. In this case, the caretaker government run on the discretion of the president. Next is, under the Article 78C, President can refer an individual decision of any minister as an collective consideration of the whole cabinet minister, so that cabinet of minister as a team can be held responsible of his action. This collective responsibility of the COM is enforced in Lok Sabha by the president. This means, suppose in the parliament there are different ministers, the even a decision is taken by a single minister, then also the decision is deemed to be the consideration of the whole cabinet of ministers. This is done to ensure that there is a collective responsibility for the action of any individual ministers, for the collective responsibility of the council of ministers. This collective responsibility is basically enforced by the president, and this is his discretionary power. Now, since we have done with the discretionary power, we will talk about what are the military power. So, military power of president means president is the supreme commander of the armed force, and he will declare the war and he will declare the peace. So, this is the military power of the president. Second is the legislative power. What is legislative power? A bill, when passed by both the house of the parliament, will become an act only when it gets assent from the president. So this is the power of the president. Which power? Legislative power. Second, president summons the house of parliament as well as prorogues the house of the parliament. So this is again the legislative power of the president, that he has the power to summon the house of the parliament as well as prorogue the house of the parliament. Next power is that he will dissolve the Lok Sabha on an advice of the COM. He will dissolve the Lok Sabha on the advice of COM if the majority of COM is enjoyed. Otherwise, by his discretion, if majority of COM is not enjoyed. This means if there is majority of the COM, then the president will dissolve the Lok Sabha on the advice of COM. If the COM is not enjoying the majority, then president, by using the discretionary power, will dissolve the COM. But in both the cases, it is the power of the president to dissolve the Lok Sabha. This power is again the legislative power. Fourth is what? Fourth is it contains it. Okay, certain bills before introducing in the parliament need recommendation from the parliament, needs recommendation from the president. It is wrongly written here, from the president, like the money bill, financial bill, ordinary bill under the Article 3 only. So there may be some bill like ordinary bill, like Article 3 bill. Article 3 means name change of the state and the change of the boundary. So certain bill before introducing in the parliament needs a recommendation of the president, like the money bill, financial bill, ordinary bill. So other ordinary bill and constitutional amendment bill does not need the recommendation of presidents. So other legislative power is that president also nominates the 12 member of the Rajya Sabha. This is again his power. The next power is that president causes the certain reports or bill to be introduced in the parliament. So it is the power of the president that because of this power he will ask report to be submitted. So president causes the certain reports or bill to be introduced in the parliament. So this kind of bill are like the budget. Budget means annual financial statement, which we call the budget. The report of UPSC, CAG, finance commissions, and the third is the National Commission for Backward or SC/ST reports. These all reports is laid into the parliament, and it is the presidential power. Seventh power is the president also delivers and addresses the first session of the parliament house separately or jointly after the fresh election of the Lok Sabha or the first session of each year beginning. Now let's talk about the diplomatic power. What is the diplomatic power of the president? So president represents the India in international forum. Whatever is the international forum meeting going on, president will represent the India. Second, all the international treaties which are there and agreements which is being made between the two countries, they are signed in the name of president. Third, the president will send and receive the ambassadors. So all the ambassadors which is sent outside the India or coming in the India, that will be in the name of the president. Next is the administrative and executive power. So all the executive or actions are carried out in the name of the presidents. So whatever is the executive actions of the union, they are being taken out, they are being done in the name of the presidents. This is also mentioned in the Article 53. The presidents appoints the different bodies. President will appoint the prime minister, he will appoint the other ministers of the union, he will appoint the CAG, he will appoint the attorney general, he will appoint the judge of Supreme Court or High Court, he will appoint the Chief Justice of India, he appoint the governor of states and different things. So this is also the appointing power of the president. Now in fact every appointment that is there under the union government is made in the name of president or his authority. So every appointment under the union government is made in the name of president or under his authority. So he has appointed those guys, he will also remove those officers. Now let's talk about the financial power. Financial power 1. President calls the annual financial statement, that is budget, to be laid in the parliament. Second, money bill is introduced in the parliament only with the prior permission of the president. Okay, so there should be the prior approval of the president in order to introduce the money bill in the parliament. Third, money is drawn from the contingency fund of India only with the approval of presidents. So if the president approves, then only one can withdraw the money from the contingency fund of the India, and it is the power of the president that money is drawn from the contingency fund of India only with the approval of president. Fourth is he constitute the finance commission every 5 years. So every 5 years a financial commission will be constituted, and he has the power to constitute the financial commission every 5th year. Fifth, no demand for grant can be made without the recommendation of the presidents. So if one is asking for the grant for demand, then grant for demand permission can be given only after the recommendation of the president. Now let's talk about the power of presidents which is there under the Article 72. So president has power to grant the different things. One is the pardon, one is the reprieves, and the other is the respite, and there is some other power like the remission and the commutation and the commutation. So we will take one by one. What is the pardon? Pardon means completely absolves all the punishment and offenses or conviction. So means baijat bari. So this means completely absolves all the punishment and offenses there is with a victim. Second, reprieves. Reprieves means it lays down the temporary stay on the execution of sentence. So there is a temporary word mentioned. So temporary stay on the execution of sentence is the reprieves. Then third is the respite. What is respite? Respite meaning is lesser punishment or intensity of punishment is reduced. This means respite means awarding a lesser punishment or reducing the intensity of punishment on the very special ground related to the convict, like physical deformity and the pregnancy. So what is remission? Remission is different from the earlier, that was the respite, in the sense that in the respite we have a lesser punishment, or intensity being reduced because of physical deformity, pregnancy, and special grounds. But in case of the remission, one thing should be taken care of, that changing of the real character is not allowed. This means the only the length of the punishment will be reduced, but without changing the real character. This is called the remission. And another is the commutation. What is commutation? Commutation means substituting one form of punishment from another, यानी कि substituting the one form of punishment to another, which is of the lighter character. This is the commutation. Things to be taken care of, that only president can pardon death sentence, not the governor. Only president can deal with the judgment or conviction made by the military court. So if some judgment is there, some conviction is made by the military court, then only president can deal, not the governor. Under the Article 72, under Article 72, when exercises power is executive power but not a judiciary power. So this means actually president under the Article 72. President under the Article 72 when exercises the power means like pardon, reprieves, the commutation, remission. So this kind of power which is mentioned in the Article 72, when the president exercises such power, then it is the executive power of the president, it is not the judiciary power. This means upon its use, president does not become the court of appeal. This means you cannot appeal to the president, please give me the remission, give me the commutation, etc. This means president have the discretion to act in this area or not act. I mean under the Article 72. So, but the judicial review can be done for the executive power under the Article 72. So under Article 72, the whatever action was taken by the president, their judicial review can be done. Now let's talk about the power and position of the Indian president. Is Indian president very powerful or not? Let's talk in this regard. So power of the Indian president, we will see that there are some power as per the constitution, that is called the constitutional perspective. We will also see the power and position of Indian president from the judiciary perspective. We will see the power of president from the perspective of constitution maker. So when we see what is the power and position from the constitution, from the judiciary perspective, from the constitution maker, then after that we will see from the viewpoint of actual working on the ground what is the position of Indian president, and then we will decide is Indian president powerful or not. So let's talk about the constitutional perspective. So Constitution offers the elaborate power to President of India. Sorry for disturbance, we will again look here. So constitutional perspective means Constitution offers the elaborate power to the President, but due to the Article 74, that is, he has to use this power on an advice of the COM. So from the Constitution, although it has given elaborate power to the President, but due to the Article 74, he has to use this power only on the advice of COM. Okay. Second is that Constitution provides for the parliamentary democracy in India, where real power vests with the COM and the head of the state is just the nominal head. So India has the parliamentary democracy, and the real power is there with the council of minister, and the head of state and the president is only the nominal head. So this is as per the constitution. Third point is that constitution does not even explicitly mention the discretionary power of the president. Means in nowhere in the constitution we will find the discretionary power of the president. Therefore, the office of president does not appear to be very powerful from the constitutional perspective. Okay. Now let's talk about the judicial perspective. So judicial perspective, the Supreme Court have clarified different points for the judicial power or judicial perspective of the president. One, Supreme Court already clarified that Constitution lays down the parliamentary democracy in India. Therefore, the head of state is only the nominal head, and the real power lies in the Constitution of Council of Ministers. Second, all the executive decisions of India, though it is taken in the name of the president, but are actually the decision made by the COM. So it is not the power of the president. Third, when the constitution says it is the president, when the constitution says it is the satisfaction of the president, then it means satisfaction of council of minister, not the satisfaction of president. Third, third is that even when Lok Sabha dissolves, there is a caretaker council of minister which will aid and advise the president. This means president cannot even exist or discharge its function, executive function, without the advice of COM. Therefore, from the judiciary perspective, also president office does not seem to be too powerful. Again, from the perspective of the constitution maker, we will see from the Dr. B.R. Ambedkar statement that he has the view as shared by the Supreme Court that president is nominal head just like the British monarch, where he simply represents the country but he does not rule. Second, Dr. Rajendra Prasad view is that he argued that though we have taken parliamentary system from the England, we need not model the Indian system completely in line with the British monarch, because their head of state is hereditary and India's head of state is elected, and only the good president can be elected and re-elected. Thus, the president cannot be simply a tool in the hand of the Council of Ministers. Now we will see on the actual working on the ground. So, with the same power of the president, we have seen that very personality of the president can also make the big difference to the power and position of the Indian president. We have seen some active president like Rajendra Prasad, like K.R. Narayan, like Pranab Mukherjee, like H.D. Sharma, like A.P.J. Abdul Kalam, like Jail Singh, like R. Venkat, like R.R. Narayan. They have asserted themselves in the interest of democracy and to stop the Council of Ministers and even the Parliament from acting against the interest of democracy. So they have asserted themselves. So they have made look like the power of president being powerful. Also, there have been some precedent which were not proactive, making the office of president appear to be less powerful. Former President V.V. Giri rightly said that today political party fighting to get their candidate to become the president is testimony or is the proof that this office is not titulus or not rubber stamp. This means this office has a value. Similarly, R. Venkatraman explains that Indian president is just like an emergency lamp. Which lamp? Emergency lamp, which is not visible or assertive in the normal time, but become proactive and assertive whenever there is a danger to the constitution or danger to the basic provision to the constitution. So from here we have also talked about the provision of Indian president. Okay, so in this way we have done it. In India in 2022 there was the 16th presidential election held. And the 15th president of India was elected. Election was on the 18th July. Secretary General of the Rajya Sabha acted as the returning officer. So I think we have done this. After this, there will be the governor. So governor, if you want, we will finish the governor also. Sorry, vice president. So let's talk about the vice president very fast. Vice president is the second citizen of India. As we know, first citizen of India is the president, vice president, second citizen of India. Union executive is president plus vice president plus UAM plus attorney general. So what is the union executive? Union executive means president, vice president, council of minister, and attorney general. Okay. So vice president is the second citizen of India. Office of vice president is modeled on the line of America's vice president. Unlike the president, the electoral college to elect the vice president does not include the state legislative, and even nominated member of union participate. This means in order to have the electoral college of the vice president, there we don't have the state legislature, but we have even nominated plus elected member of the union. So elections are held in the similar lines like the Indian president, that is conducted by the Election Commission of India. Though proportional representation and single transferable voting system through the presidential proportional representation and single transferable vote system. Election through the single ballot. There will be the single ballot. Whip is not issued. The secret ballot will be there, and whip is not issued. Winner has to get more than 50% first preference vote, and the vote value of an MP is 1. The vote value of member of parliament will always be 1, because there is only the member of parliament who is voting, casting the vote, not the electoral. So there will be the representation, proportional representation, single transferable vote system. It is written single ballot. I will check whether it is single ballot or secret ballot. And whip is not issued. Winner should get more than 50%, and the vote value of MP is always 1 for the vice president election. So what is the qualification? Qualification is very simple. Qualification is he should be the citizen of India, and age should not be less than 35 years. He should be qualified to be elected as a member of Rajya Sabha, and he should not hold any office or profit under the union or any state government or local authority. However, there are some exemptions to the office of profit, like the vice president, governor, minister of union, state is not considered as the office of profit. Third, before entering the office of the vice president, the winning candidate must give up the membership of the legislature, whether of union or a state, if at all he was a member. It's like the president. It's the same thing. If a member of the state or union becomes the president, vice president, then they have to first of all give the post. Now nomination. So what was the nomination? The vice president candidate has to be proposed not less than 20 electors and seconded by not less than 20 electors. In case of the president, it was how much? It was 50. But in case of the vice president, it is just 20. So this is also important. That is why we should always study the president, vice president together. Oath. The oath to the vice president is administered by the president, not by the Chief Justice of India, like in the president case. So, and some other person appointed by president or in behalf. This means the oath to the vice president is administered by the not by the CJI but by the president. And if president is not there, then it may be also done by some other person or in his behalf. Okay. Vice president hold the office for 5 years from the date on which he enters into the office, and can resign by addressing the resignation to the president. Removal. So he can be removal can be introduced only in the Rajya Sabha. 14-day notice is to be given for Rajya Sabha, not less than 50% member of the House. That is, vice president can be removed from the office before 5 years by a resolution passed by the Rajya Sabha. In case of the president, resolution can be initiated in any house, but in case of the vice president, resolution has to be initiated from the Rajya Sabha, and it needs to be passed by majority of the member of Rajya Sabha. That is, effective majority is needed, and agreed by the Lok Sabha also, simple majority. This means in order to remove the vice president, resolution has to be initiated from the Rajya Sabha, and there the Passing system is the majority of the members of the Rajya Sabha, that is effective majority, and it will again go to the Lok Sabha, and in Lok Sabha it need to be passed by the simple majority. However, such a resolution of removal is introduced in the Lok Sabha. Before it is introduced in the Lok Sabha, 14-day notice has to be served to the Vice President. No ground has been mentioned for the removal of the Vice President. Re-election. Election for new Vice President is to be held before the expiry term of ongoing Vice President. So before ongoing President is expired, election need to be there. How? So let's say if there is a vacancy in the office of Vice President because of death, resignation or removal, then election for the next VP will be held as soon as possible, not within 6 months. This means if there is vacancy in case of the President, then that should be held within the 6 months, but in case of the Vice President, it should be as soon as possible. This means 6 month criteria is not there. And the newly elected Vice President occupy office for full 5 years and not the remaining term of previous Vice President. This means once election is there, a new Vice President is coming in the office, then he will hold for next 5 years. It is not that he will hold only for the remaining term of the previous Vice President. If election for President or Vice President office cannot be held before the expiry of the term, the same officer will continue in the office till the new office is elected. This means if the election of President or the Vice President office cannot be held because of some reason before expiry of term, then some officer will, the same person will continue in the office till the new is elected. No problem. Now we will talk about the different functions of the Vice President. Vice President acts as the ex officio chairman of the Rajya Sabha. That is very simple. American Vice President, if act as the President due to American Vice President, if act as President due to vacancy in President office, then remains as President for full. So I'm taking an example. In the America, if the Vice President become or act as a President due to vacancy in the President office, then he will remain as the President for the full term, for the full remainder of the unexpired term of his preceders, not just for maximum of 6 months as in case of the India. Because in case of the India, the vacancy election need to be there within the 6 months. For the Vice President election need not to be in the 6 months, it should be as soon as possible. In case of America, if the Vice President become the President, he will continue his all remaining term. But in the India, for the 6 month, Vice President can become the President because there will be the fresh election within the 6 months. It implies he was not supposed to act as powerful office as American Vice President. This means in India, the post of Vice President is not as strong as powerful as American Vice President, and also called his superfluous highness. This means he is known as the superfluous highness. Constitution did not specify or fix any emolument for the Vice President, and he draws the emolument only as an ex officio chairman of the Rajya Sabha. This means the emolument salary of the Vice President is not there. He withdraws the emolument not as the Vice President but as the ex officio chairman of the Rajya Sabha. But when acting as the President, he get all the emolument and privilege as the President get. That is very simple. Note, Vice President can act as a President for a term of more than 6 months only in case of the absence of President. Now we will talk about the removal process. So for the removal of the President and Vice President, we have make one table. So resolution can be introduced for in case of the President. It can be in any house, Lok Sabha, Rajya Sabha, with a minimum of 1/4 member is required there. Okay, for supporting. Notice has to be there for 14 days. And majority, if you talk about, then 2/3 of the total members of the house, in both the cases, house will be required, and ground will be the violation of the constitution, and re-election within the 6 months. In case of the vice president, it can be introduced only in the Rajya Sabha and 14-day notice is required, and effective majority in the Rajya Sabha and simple majority in the Lok Sabha is required, and the ground of also is not mentioned, and the election should be done in as soon as possible. So this is all about the president, vice president. We have taken all the points, all the aspect of president and vice presidents for any examinations. This is all about. Thanks guys. Bye bye.